The biggest mistake slip and fall and trip and fall victims make is they sit back and hope that the insurance company will make them a fair offer. And this is a mistake because they expect that the insurance company will do the right thing. I'm going to tell you how to value slip and fall and trip and fall cases and how to increase your odds of getting the largest settlement in the shortest amount of time and not just sit back and hope that the insurance company will make a fair offer and do the right thing. The number one factor that determines the size of a slip and fall or trip and fall injury settlement is how badly you are injured. Just take a look at some of these settlements. We got a $325,000 settlement for a client who tripped and fell and he broke some bones in his arm and had a plate and screws put in them. In another case, we got a $300,000 settlement for a slip and fall at a supermarket where my client's injury was 2 skin graft surgeries to his lower leg. In another case, we settled for $250,000. My client slipped and fell at a hotel bathtub and had a plate and screws put in her arm and then a second surgery to remove the plate and screws. In another case, my client tripped and fell on a surface that she claimed was uneven. In other words, there was a step up that she didn't see before she fell. She broke her arm bone and had a plate and screws put in it, and we settled that case for $240,000. What you can learn from those settlements is in every one of those cases, my client was badly injured. If you take those same cases and my client did not have a bad injury, the settlements would have been much smaller. And we're going to get into discussing fault and liability in just a few seconds. I've been a slip, trip, and fall lawyer for about 18 years, and I looked back at my past cases and I noticed something very interesting. In every case I had that settled for $64,000 or more, my client had surgery. So without surgery in a slip or trip and fall case, I would not expect a settlement above $64,000. Can you still get a settlement for over $64,000 if you slip or trip and fall? Yes, but it's unlikely. Juries typically award more money if you have surgery, and insurance companies know this and they make higher offers as a result. Slip and trip and fall cases involve negotiation. The insurance company for the place where you slipped and fell or tripped and fell is much more likely to greatly increase their settlement offer if you're badly injured. Let me give you an example. I represented a client who stepped on an uneven surface at night and he broke his arm and had surgery and a plate and screws put into his arm. The insurance company's final offer was $175,000 above their initial offer. In another case, the insurance company offer was $0 where my client slipped and fell in a supermarket, and we ultimately settled after a lawsuit for $300,000. And in another case, my client slipped and fell in a hotel bathtub that we argued was unreasonably slippery, and the settlement was over $237,500 above the hotel insurance company's initial offer. But again, in that case, my client had a broken arm bone and surgery. And in a case where my client tripped and fell over a surface that we claimed was uneven, the hotel's final settlement was $220,000 above their initial $20,000 offer. If you've had a plate and screws put in your body as a result of a slip and fall or trip and fall, it is not uncommon for the insurance company's offer to be $100,000 or more over their initial offer. Is there a guarantee that this happens? No, not at all, but it's not shocking. I looked back over my slip, trip, and fall cases in the last 5 years, and I saw that 92% of them were for settlements under $325,000. So the odds are greatly that your slip and fall or trip and fall case will be worth less than $325,000. Generally speaking, if you have a broken bone or ligament or tendon tear with surgery, it's worth a lot more than without surgery. Slip, trip, and fall cases typically take longer than car accident cases to settle. This is because the insurance limit of where you slip and fall or trip and fall is often much higher than the insurance limit in a car accident case. What this does is it puts less pressure on the insurance company to settle because they're not afraid of the place where you sued having to sue them if they get hit for a verdict above the insurance limits. Whereas in car accident cases, if someone that hits you has a $25,000 insurance limit or so, and you have surgery to a body part, the insurance company knows that if the other driver's at fault, that case is worth over $25,000, and they get nervous. They don't want their insured to sue them for above the $25,000 for failing to pay you. If you slip or trip and fall and don't have a serious injury, the case really isn't worth much. And if the employees are laughing at you after you trip and fell or slip and fall, that really doesn't add much value to the case. When thinking about how long your slip, trip, and fall case is going to take to settle, consider the date that you finish your medical treatment, because that's when you're ready to settle. Before that, you're not going to know how badly you're injured, and typically as you continue to get treatment, it increases the full value of your case before factoring in your fault, if any. Now, slip and fall or trip and fall cases are not easy. In fact, I'm close friends with an attorney who says he's not a big fan of slip and trip and fall cases. And I know lots of people who, when they hear about slip or trip and fall cases, they say they wouldn't award the victim any money. Does it matter if paramedics come to the scene after you slip and fall or trip and fall? Yes, and it really matters even more if there's no video surveillance and there was no witnesses to the accident. You may have a higher chance at getting a settlement without a lawsuit if paramedics came to the scene, because the insurance company knows that you were actually injured at the place where you're claiming to be injured. Now, in order to have a winnable slip or trip and fall case, the place where you fell has to be at fault. Just because you're injured somewhere doesn't mean that they're going to pay you a penny, and they don't have to. The exception is if the place where you fell has what's called med pay coverage on the insurance policy. They pay that coverage for your medical expenses regardless of fault. And the med pay limit is typically $5,000 or $10,000 or so. In order to win your slip and fall or trip and fall case, you need to show that the place where you were injured knew or should have known of the hazard that caused your fall before the accident. It's best to report your accident immediately when it happens. It's great if the paramedics come to the scene and you can prove that you were injured there by them coming. However, you still want to send a letter to the business owner letting them know to preserve video surveillance and any other evidence so you can prove your case. Here's an example of how not reporting a slip and trip and fall accident and paramedics not coming to the scene delayed settlement. I sent the insurance adjuster, in this case, photos of the hazard that caused my client to fall. The insurance adjuster said, listen, I'm not fighting liability. In other words, she was saying, look, we acknowledge that we're pretty much wrong. What we need to look at is how badly your client's injured and just come up with a calculation for the settlement value of that. Later, the adjuster said, I made a mistake. Your client never reported the accident to the owners of the place where she fell. So liability is not clear. Now, had my client called 911 and we could have gotten the 911 call in that case, or if paramedics had came due to the 911 call, or if she would have reported the accident shortly after it happened to the owners, the adjuster may have accepted liability. But because she didn't do any of those things, the adjuster said, I cannot accept liability. And a case like that can require a lawsuit, which can take more time, and then you have to pay your attorney an increased fee. For example, in Florida, the fee increases from 33 1/3% of the total settlement to 40% once your attorney sues. Do not expect the insurance company in a slip and fall or trip and fall case to send you an email or put it in writing that they admit liability and that their client was at fault for the accident. I've only had it 2 times in my career, and in both of those cases, we had good photos showing the hazard where my client claimed caused their slip, trip, or fall, and we sent that quickly to the insurance company. On the other hand, in a car accident case, insurance companies often will put in writing that they accept liability and that their insured was at fault. You want to take good photos of the hazard that caused your slip and fall or trip and fall. You also want to use a ruler or measuring tape to measure whatever it is that caused you to slip and trip and fall. If it's a change in elevation, a change in height, a misstep that you couldn't see prior to walking, you're going to want to measure the height of that. If it's liquid, you're going to want to measure the length of liquid. You do not want to just rely on looking at a picture and guessing how much the change of elevation is. This measuring tape or a ruler can be your best friend. I'm going to give you an example of a common mistake when taking photos in a trip and fall or slip and fall case. My client Shirley was injured at a hotel where she claimed that she tripped over a change in height of the walkway. Now, she had a friend come to the hotel and the friend took photos, and the photos showed that the area was blocked off. However, her friend did not walk all the way up to the area and take a photo showing the change in height. And by the time my client sent me photos, I couldn't see anything wrong. I didn't see a change in height, so I assumed that the hotel fixed it. But it would have been so much better if my client's friend would have taken photos that showed the change of height. And ideally, if she could legally get up to that area to use a ruler and measure the change in height. Now, in this case, we were a bit lucky. The insurance company really didn't argue fault. And if the insurance company is not arguing fault in your slip and fall or trip and fall case, do not mention how the accident happened to them. Let it be. Now, don't get too excited. In most slip and fall or trip and fall cases, the insurance company for the place where you were injured will say that they're not at fault. If there were no warning signs and that may have prevented you from slipping and falling or tripping and falling, take photos of the hazard showing that there were no warning signs. In this image here, you can see a door that my client exited in a condominium building, and it did not have any warning sign on it. And there was a step down, and she stepped down. She didn't know about the step down. She fell downstairs and broke her nose and had surgery, and we settled the case for $73,000 plus $5,000 in med pay, but we had photos showing that there was no warning sign. I also sent someone from my office to go out there and measure with a ruler, showing that the drop off after you exited the door was very large, and that was not okay. It was great that we got a measurement showing the change in height when you exited that door, instead of just relying on looking at a picture and thinking that you know how much the drop off is. To get compensation in a slip, trip, and fall case, you need to show that the place where you were injured knew or should have known about the hazard that caused your injury. One way that you can show that the place where you fell should have known about the hazard that caused your fall before you get injured, again, is with photos. If the water was dirty or had track marks going through it, you can argue that the water had been there for a long time and the business should have known about it. Here in this photo, you can see my client lying on the floor, and we argued that the dirty spots showed that the substance had been on the floor for a while before my client fell. The longer the substance or hazard was there before you slipped and fell, the better. And if the hazard that you slipped and fell on or tripped and fall on occurs very often with regularity, that can make the place where you were injured liable for your injuries. For example, this is a photo of a condominium walkway, and there's an exit sign hanging from the ceiling above. Now, whenever it would rain, the exit sign would drip water onto the floor, which would cause the floor to get stained. So a good photo showing the stain on the floor and of the dripping exit sign or video can show that this situation occurred regularly and frequently, and that would put the business on notice, or the condominium association on notice, and can help you prove your case. Now, expect the insurance company for the place where you were injured to argue that you're at fault. Fault is a tremendous factor in slip and fall and trip and fall cases. Now, some states are more generous than others. A state like Florida, which is where I'm a slip and trip and fall attorney, allow the injured person to recover even if they're 51% or more at fault. However, you only get paid for the place where you're injured, their percentage at fault. So if the place where you were injured was 40% at fault for allowing something to be on the floor that caused you to slip and fall or trip and fall, you'll only get 40% of the full value of your case. That's 40% of the medical bills and your pain and suffering and your lost wages. And some states are harsh. Even if you're 1% at fault, you can recover nothing. Thank God I don't practice in one of those states. So if you slip and fall or trip and fall in Florida, count your blessings that at least you were injured in a state where you can be 51% at fault or more and still have a case. There's often less fault on you if you slip and fall or trip and fall at night and the area is not well lit. This is because you can argue you couldn't see the hazard before you fell. Now, expect the insurance company for the place where you slipped and fell or tripped and fell to argue that you weren't looking where you were walking, that you were rushing, that you were given a warning that you shouldn't walk there before you slipped and fell or tripped and fell. Here's an example where the insurance company for a mall used two of those arguments against me in an email. The adjuster said that my client was warned not to walk through the parking lot where there was some construction going along, and she also said that employees said that she was rushing. So they argued because of these two factors, they only owed $55,000 to pay for her foot surgeries. And unfortunately, the photo that you can see was the best photo that we had for the case. This is taken by someone that she worked with at the time of the accident. And you can see my client using a walker here because she had a broken foot. Now, we settled the case for $120,000. However, the case would have been worth a lot more if the employees who were performing construction did not believe that my client was rushing, and if they had never warned her not to walk through the area. My client said that she was never warned not to walk through the area, and she said she was not rushing. Unfortunately, my client did not have health insurance in that case, so she got a lot less money than she would have received if she had health insurance. After my attorney's fees and costs and paying back the hospital and doctor, she received over $45,000 in her pocket. And like most trip and fall and slip and fall cases, most of the settlement was for pain and suffering. If there was a slippery when wet sign, that could kill your case or result in a lower settlement offer. Here's an email from a insurance adjuster for the hotel where my client slipped and fell in a bathtub. And you can see in the email, She says that part of the reason why her initial offer is for $12,500 is because she said she sent an investigator to the scene and there are slippery when wet signs. Here's an example where the insurance company argued that the cracks that my client slipped at a private nature park were open and obvious. She put in writing when making her $5,000 offer that the area was open and obvious, and that's part of the reason why she was only offering $5,000 for my client's broken ankle. And oftentimes, if the area is really open and obvious and really a disaster, it's actually worse for your case because the insurance company says, how did you walk through this area? It was so obvious that there was a problem, you should have avoided it. In that case, we settled it for $30,000. So you can see that insurance companies often give an initial lowball, very low offer. Lighting can greatly affect the value of your case. If the area is well lit and you should have seen what you slipped there or tripped and fell on before you fell, expect the insurance company to offer you much less money. On the other hand, if it was very dark and it was almost impossible for you to see the area that you slipped or tripped and fell over and there was a problem, expect the insurance company to hopefully offer you a lot more money. Now, the county where you slipped and fell or tripped and fell can have a large effect on your settlement. You can see by looking at this map, the blue areas are ones where juries typically award larger amounts for slip or trip and fall victims, and the red counties are ones where juries typically are more conservative and award less, all things equal. Now, the county where you were injured is not the largest factor in a slip and fall or trip and fall case. What's more important than where you were injured is how badly you were injured and whether the place where you were injured did anything wrong to cause your injury and slip, trip, and fall, and your fault in the accident. Now, if an employee of the place where you were injured mopped and failed to put up a sign, they can be at fault because they created the condition that caused your fall. I had that happen in a case against a hotel. My client wasn't aware that the area was wet. An employee earlier had mopped the area, and I got a witness to sign an affidavit stating that she saw the employee mopping the area before my client got injured. However, before I gave the insurance company for the hotel the witness affidavit stating that she saw someone mop the area before my client fell and there were no signs, they offered zero. In 2021, you can see that half of my settlements were above $240,000 and the other half was below $240,000 for slip, trip, and fall cases. I've shared some mistakes to avoid in a slip and fall or trip and fall case so that you can get a fair payout, but there's a lot more mistakes that I didn't talk about. To learn about common mistakes that can cost you a lot of money in your personal injury case, watch this video here. And if you're seriously injured in the state of Florida or on a cruise and you're considering hiring an attorney, fill out the contact form in the link below, and I'll see you next time.